Mr. Rose, we'll start with you. Good evening and welcome.
Good evening, Madam Chair and members of the committee. I usually do not speak on gun bills. This is the first time I've ever spoken on a gun bill, but I do think it's a complex issue, but I am speaking very strongly against the red flag gun bill 2492. Because I think the way it's drafted has considerable flaws. The bill is phrased in terms of extreme risk. That's the official name of the court order. But in terms of the legal language, the order is issued even if there is no extreme risk to the alleged gun owner or to anyone else. In fact, the law says, if this bill passes, it says that the alleged gun owner, the respondent, has to have the order issued against them, even if nobody in the court thinks they're a danger to anybody else, and even if there's just a suspicion that there's a significant risk to themselves, which may not be an extreme risk. All that's needed is a significant risk. So the bill says that when there's a significant risk to oneself or others, the order has to be issued. And the standard of proof for it is pretty weak as well. They don't have to prove beyond a reasonable doubt that somebody is a danger. It's simply whatever the judge finds to be clear, convincing evidence. But more importantly, besides the standard of proof, is that the grounds that the order is based on are left very vague and bring in a lot of potentially extraneous issues. If this was a bill about about taking away people's guns when they've actually made threats, then I would think that's a great idea. I would not be against that. But the bill actually sets out a pretty wide range of criteria that the judge is supposed to consider in issuing this order. The judge is told to look at the respondent's mental health history, to look at the respondent's alcohol use or drug use, so, for example, some judges do not like people who use drugs or even legal medical marijuana, but the judge is asked to consider that in issuing the order. And as the ACLU has pointed out, the way the bill is written, even political rhetoric could be considered a threat and grounds for taking away a person's guns. But I haven't even gotten to the worst part, because even though there's a variety of enumerated criteria, such as whether the person has purchased a gun recently, or whether the person drinks alcohol, or whether the person has ever seen a psychologist, or whatever their mental health history is, the judge is actually allowed to issue the order if none of those criteria is true, because the bill says that the judge can use any grounds that the judge happens to consider relevant and credible in issuing the order. So there's a whole lot of subjectivity in the bill, and I'm troubled by that. I'm troubled by that because I know the record of the court system. The court system, studies show the court system does discriminate. A black person or a white person with similar background are often going to be treated differently in the courts, and drug use is considered differently when it's a person of color than when it's a white person. If you can afford a lawyer when you go to court, then you're treated differently than a person without. And under this bill, there's no right to a lawyer. If you can afford a lawyer, and if your lawyer if the lawyer you want is able to make it at the time the hearing is scheduled, you can use a lawyer. But a lot of people are going to be in there without a lawyer, and it's because the bill is so subjective in the grounds for this order, and there's no requirement that there should be any evidence that the person has made threatening remarks or threatening actions, the judge's subjectivity is given free rein, and I think we know enough about the flaws in the court system to know you don't want to do that when the consequences can be pretty serious. And in fact, the consequences are serious. I want to talk particularly about the temporary, what this calls the temporary extreme risk protective order, because the way that works is the police show up at a residence, and none of the residents know in advance that the police are going to be coming. There's no notice to the residents. The person who is the subject of the order doesn't even know that this was even being considered, and nobody else who lives there knows to expect the police. But the police come in, and they've been ordered by the judge to take away the guns. So the police are not going to be gentle in doing this, because they've been told by a judge, no less, that this person is an extreme risk. Never mind the fact that the evidence might not show anything about the person being a risk to others. Maybe it's just somebody thinks there's some risk of the person committing suicide. But the police come in thinking that this person is an extreme risk and wanting to carry out the judge's order by making sure they grab all the guns. And when you have that kind of situation, a lot of police are going to get agitated and aggressive, because police want to make it through the day. If they're told somebody's an extreme risk, they are going to act, in many cases, act aggressively to protect themselves. That's why swatting is a big deal. When some anonymous caller calls a SWAT team with a false report on somebody, often people get killed or injured because the police are told to expect a great deal of danger. That's what this bill's language does, because it says somebody is dubbed an extreme risk, even if they're no risk to anybody else, and the police know to expect danger. They know to expect guns there, and if they see anything that's unexpected or not to their liking, there's what I would think is an unacceptably high risk that innocent people are going to get hurt or killed, maybe not even the person who was the respondent for the order. So that's a very dangerous procedure. Unfortunately, anybody who likes can swear out an affidavit and just say this person is an imminent threat, and then there's an ex parte hearing. The respondent isn't even notified, doesn't know what's going on, doesn't have a right to respond. And if the judge, for whatever reason, is convinced that this person is a dangerous character, then you get this unannounced police raid, and that can cause a lot of problems. I think that's bad when there's so much invitation to the judge to be subjective, because for whatever reason you strike, from the reports given to the judge, you strike the judge as a dangerous character, even if there's not much objective evidence that you've talked of violence, then they may well decide they've got to issue this protective order. And this is the only time in our law where you have an ex parte hearing. That's the only time, as far as I know, when you have an ex parte hearing where a person isn't represented, which then issues in a police raid. I mean, in theory, when the police show up, you could meet them, say, sure, I'll give you my guns, but I think, and things might in theory go calmly, but I think they would still want to ransack the place at the very least and turn it upside down. And if you don't have the presence of mind to respond that way, things could go south pretty rapidly. I think at the very least this bill should be rewritten so that it requires some objective showing that the person has acted violently or has spoken in no uncertain terms about violent acts. And I don't mean just political rhetoric that a court might easily mistake for a threat of violence if the court isn't warned differently in statute. Another problem I really want to highlight with this bill, and other people have touched on this, is the way it deals with mental illness. I get that we're concerned about suicide. I get that people want to prevent somebody from committing suicide. But the way this bill treats mental illness is the judge has to look at the respondent's mental health history, and mental health history is considered a red flag, not just for harming yourself, but for harming others. So mental health history can be used as support for the theory that a person is about to harm somebody else. And just that kind of blanket use of a person's mental health history as signaling they might be a danger to others fits into the worst stereotypes about mental illness, which some of the other people have warned you about. They point out that only 1% of the people who have been violent have actually been mentally ill. And unfortunately, that's just part of this very subjective process that the judge is being placed into. And when you have a subjective process, one thing we know is stereotypes come into play. But another problem with the way this bill treats mental illness is that even if a person is genuinely at risk for suicide, the bill's way of dealing with that is to send the police and perhaps on an unannounced raid and try to grab the guns away. I don't think you want to mix aggressive policing with mental illness in the case, particularly in cases where there's no reason to think somebody's a danger to somebody else. In this bill, the police aren't even warned that the judge didn't think the person was a danger to anybody else. It's just that this bill says that if you're considered a risk for suicide, they're going to treat you exactly the same as somebody who's considered a possible pre-criminal. So it's conflating mental illness with pre-crime. And when the bill sets up police officers to feel like they're in danger of their life, that's not going to be a recipe for the most sensitive way of treating people with mental illness, and might cause police to treat someone with mental illness in a way that exacerbates the problem. I know that we want to prevent suicide, but the way to prevent suicide is not necessarily by just focusing on grabbing guns away. Because say it works, say the police raid works, they do grab the guns away, nobody's injured when the guns are taken, but still an aggressive and traumatic police raid is not going to have the best effect on somebody if they actually are at risk for suicide. It might actually just lead to a situation where they find some way to kill themselves later on by some other means. And there's nothing in this bill that actually suggests adequate an enlightened approach to mental illness. The closest thing in this bill to an enlightened approach to mental illness is when they say that the court officers are supposed to come up with a list of mental health resources, and then they may display this list of mental health resources next to the brochures where you apply for a court order to take away someone's guns. That's not going to help at all. Basically, the bill focuses on using force against people who are deemed suicidal and not on getting them any help. And the way it does that is likely to make things very much worse. I also am concerned about the racial aspects of this. There are many neighborhoods where people of color live where it's more or less common for people to own guns. They feel they need that for protection. But because the bill gives free reins to the judge's subjectivity, what's likely to happen is people of color are going to be disproportionately targeted by this audience. By this bill, people with mental illness are going to be disproportionately targeted. People people with unpopular opinions are going to be disproportionately targeted. If you're a person who has a lawyer and your background is something the judge finds appealing, you're not going to be as likely to be targeted by this bill. Now, I'm all for a society where we don't have guns. I think that would be great, but I just don't see this bill as a step in that direction. Realistically, what this bill would do is make this more of a society where a lot of privileged people have guns and aren't questioned that often about it, and a lot of people who, for whatever reason, don't have privilege are going to have their guns taken away in aggressive ways that may lead to more problems. And that's not something I can bet behind. I don't think it's going to make society better at all. I'll also mention that the
Senator Matz.
Randall, I'm listening to you. I'm trying to follow the piece. I share your concern about certainly about the racial profiling and the aspects of race, especially in this current culture. But a lot of the people that I know and at church and whatnot, they don't own guns. So I don't want you to think that every black person has a gun. And maybe the couple of people that I do know, a couple in particular at church, they're military people. So they have based on their military experience, they have the permits and everything else. But I just wanted to. So I am concerned about the profiling, but I don't want people going around here thinking that every black family has a gun. So just, I just wanted to make you aware of that. And then the other piece, as you was talking about the let me look at my notes here. The judges, I was trying to figure out with the benchmarks versus the judicial discretion. Do I have that right? Because some things have benchmarks, if I'm not mistaken. They have to follow certain.
On some things, particularly federal, there are certain. Right.
Okay, yeah. So as you was talking about that, I was thinking about benchmarks, but and whether I want the judges to have the discretion, and then as opposed to, because what we went through with the mandatory sentencing. So then when the market crashed in 2008 and they found out that the economy, it was hurting all the state budgets, then they got away from the mandatory sentencing, and then they started giving the judges discretion again. So I share some of the concerns, but I was trying to follow you on those couple of points.
Thank you, Senator. I'll just say by no means I hope I wasn't engaging in any racial profiling or stereotyping myself. I did not mean to suggest that that overall black people own guns more than white people do. In fact, I wouldn't be surprised to see it was the other way around. But what I was thinking of in particular is there are some situations where, say, young men feel they have to own guns for protection. And I don't know whether that's any more true in black communities than white communities.
Well, thank you for clearing it up on me. Thank you. I feel better. Thank you.
Yeah.
Thank you.
Yes, but it is something that's acknowledged to be true. I wasn't trying to make any overall comparison there. So yes.
Thank you.
And then I just want to say about the benchmark issue that you raised. My concern is that that when this bill is explicit about the criteria the judge should consider, and it says the judge can consider whatever standards they want, but it says some specific criteria the judges should look at. Some of those criteria, I think, are going to lead to discrimination, like when it just says, look at the respondent's mental health history, or when it says you've got to look at alcohol or drug use, or you have to look at whether this person has ever been arrested, regardless of whether they've been convicted. I think in some cases, not all judges, but in some cases, that's going to lead the judges' stereotypes to come into play, and I'm a little worried about that. So let me just say, one other topic I wanted to mention was the possibility of false accusations, which we've heard about before. Now, in theory, the bill does provide a way for some kind of accountability for false accusations if somebody falsely files a petition like this. The problem is it doesn't work in practice, because what the bill says is that somebody who files a false petition, somebody who files a petition for the court order can be criminally prosecuted if you can prove beyond a reasonable doubt that their statement was knowingly false. Now, that's a much tougher standard of proof. You got to prove it beyond a reasonable doubt when somebody makes a false accusation. You don't have to prove anything beyond a reasonable doubt when when the judge orders one of these police raids to take away a person's guns. But not only that, in order to, if somebody makes a false accusation, you can't hold them accountable unless you can show that they knew it was false. So a former boyfriend or girlfriend or whoever, if they make a false accusation, and then all they have to do is say, well, I really believe this person was a danger. As long as they can claim they were sincere in believing what they said, they can't be prosecuted for it because you have to be able to prove beyond a reasonable doubt that they knew it was false. So in practice, you're not going to be able to prosecute the ex-spouse who makes a false report. You're not going to be able, except in exceptional cases, you're not going to be able to prosecute any of these people who may have an axe to grind because they can always say, well, I thought it was true. The bill also says that police and the attorney general can directly file these requests for an order. Well, nobody's going to prosecute the attorney general for a false report. I mean, come on. If the attorney general wants to harass somebody and claims that they are dangerous, nobody's going to go after the attorney general. I would rather not give that privilege to a politician because this bill has so much potential for abuse against people this has so much potential for abuse when the petitioner has an axe to grind. I don't think somebody in a powerful position who has political allegiances should have the discretion to decide who to file this bill against, who to file this order against. If things go wrong, if the attorney general files a request that's not justified, or if police file a request basically to harass people, nobody is going to prosecute the police for that, just like nobody is going to prosecute the attorney general. So this bill puts in a lot of power to almost send a swatting call against people without any practical accountability, and I consider that very dangerous.
Mr. Rose, could I just ask you to kind of move it along? We have a lot. Thank you.